The following program, offered by Fox 19, includes lawyers licensed in Kentucky. For those lawyers to maintain compliance with the Kentucky Bar Association requirements, the phrase, "This is an advertisement," must appear on the screen. Moore Law is underwritten in the public interest by the Moore Law Firm, a legal professional association. This is Moore Law on Fox 19.
Hey, welcome to Moore Law. We're glad you decided to join us. For those of you who are new to the program, this is an attorney call-in program where you have an opportunity to call in and ask any question you have about today's subject. Today's subject is Grandpa and the Law, and what we're referring to has to do with estate planning, wills and trusts, Medicare, any nursing homes, any issue that has to do with the elderly or preparing for those eventualities. So our phone number today is 513-421-4691. Please give us a call. Ask your questions where you can get free information. Normally, we have a regular TV show professional here in this seat. That would be Deb Haas. And Deb Haas is on a well-deserved vacation, so I am taking her place. Usually I'm the attorney host, but today I've got my son helping me out, Dan Moore, who's also an attorney. Welcome, Dan.
Thanks, Dad. Good to be here.
Thanks a lot for being here.
Yep, you bet.
Listen, on this elder law business, that's something that pops up from time to time in a personal injury practice like we have. You want to talk about that for a second?
Yeah, before we started the show, we were talking a little bit about this. We have this problem with wills, and we have power of attorneys and all these kind of things that people hear about. And when somebody gets hurt in a car crash or in a medical malpractice case, oftentimes we need to get the medical records or start investigating that case. And if we don't have some of these documents that we're going to talk about today executed, then it could be a real problem.
Yeah, well, unfortunately today we've got a special guest, Karen Rolcik. Welcome, Karen.
Thank you.
Thanks a lot for coming. Karen, you've been doing this for over 26 years, haven't you?
Yes, sir. I started my career doing this and have been doing it ever since.
And elder law is, what is that?
Elder law is a type of law that involves wills, powers of attorney, healthcare powers of attorney. It also involves dealing with Medicare, Medicaid, Social Security, disability, and other issues that come up after people have retired and after they have aged a bit, and we need to deal with some issues there.
Okay, and so just tell me a couple of basic things. Who needs a will?
If you own any type of property, whether it's cash, and we're not just referring to real estate, but if you own cash, automobiles, anything of that sort, you need to have a will. If you don't have a will, the title to that property after you pass away will have to go through the probate process, and the state of Ohio has written a will for you, and it says who will receive that property. By having a will, you can direct who is getting how much of that property and when.
So if you do a will, you get to say what happens to your things after you pass. If you don't do a will, the state says.
Exactly.
Okay, good. And one of the things that I see sometimes, or I hear about sometimes, is reciprocal wills. What does that mean? Reciprocal
wills are where husband and wife, they're also referred to as I love you wills, where husband will leave everything to the wife and wife leaves everything to the husband. And those documents are fine. Except there are situations when you may have a husband and wife that die in very short order. Mm-hmm. I have a case I'm handling right now where the wife died in April and the husband died 3 weeks later. And so we have to deal with that situation. And in one will, there wasn't a contingent beneficiary. So we're going through the process, and the state of Ohio is now going to tell us who's going to inherit that gentleman's property.
Well, the lines are starting to fill. We've got a call from Sarah in Hamilton. Sarah, tell us what's on your mind this morning.
My husband passed away not too long ago, last week, and everything that he requested, it was on. He did it with the lawyer, but it was never signed. He was supposed to go back the following week, or that following day, but my husband passed away.
Well, Sarah, I am so sorry for your loss, and just happening last week. My goodness, I hope that there's information we can be of help. Karen, when a person doesn't sign a will, even if they had intention to do one, how does that work? What's the significance?
Unfortunately, if you haven't signed the will is of no effect. We have to have a signed document that will state how you want to have your property disposed of and who will be named as the executor. If you don't have the will, then we're going to, again, rely on the Ohio statutes that are going to say where that property is going to go after that person has passed away.
And Karen, in a situation like Sarah's, aren't there special provisions for surviving spouses for certain types of property, like automobiles and things?
Yes. When there is a surviving spouse, the surviving spouse is entitled to take at least one automobile, and they're allowed to live in what's called the mansion house, which is the residence, the primary residence. You're allowed to live in that primary residence for a year without paying rent. And you're also entitled to something that's called the family allowance. And the family allowance is up to $40,000 that you're entitled to, regardless of what a will would provide and regardless of what happens when there is not a will. Okay.
Sarah, I'm so sorry for your loss. I hope what Karen's had an opportunity to explain to you is of help. I would just encourage anyone who is basically falls in a category Karen talked about a minute ago. If you've got any property, or if you've got a trip, or if you've got some other thing that's imminent, it's just very important, like surgery or something, very important. You get the wills executed, you just can't put them off. It's too important to put off.
Right.
Do you have circumstances like that happen with some frequency, where people come to you after the person's passed?
Yes, I do. As you said, when surgery is imminent or someone's going on a trip, I seem to get a lot of those cases, particularly this time of year. A lot of people are going on vacation, so I get a lot of people that are coming in asking to have a will prepared because they're going on vacation. But there are many cases where an individual has passed away and they don't leave a will. One of the common things that's happening is people, husbands and wives, own real estate together. They own their home together, and it's not in what we call survivorship deed. Mm-hmm. And so it's in both of their names. And then when the surviving spouse wants to sell that property, we still have to go through the probate process, and depending on the value of that property, we may be able to do a simplified probate, but we still have to get title into the name of the surviving spouse so they can thereafter sell it.
And if they want to sell it, they've got to do a suit to sell, don't they?
Sometimes they do, yes.
Yeah. Karen, thanks so much for that. We'll be back in just a few moments, right after this pause.
Welcome back to More Law on Fox 19, your legal questions live, with local broadcaster and award-winning reporter Deb Haas and Cincinnati personal injury attorney Don Moore, recognized by Ohio super lawyers. More answers, more help, more law on Fox 19.
Welcome back to More Law, and as I said a little bit earlier, you can call us at 513-421-4691, and I am subbing for Deb today. Before we go back to the callers, there's one thing that I thought was very important to talk about, and that's how the elder law issues and some of the estate planning issues that we were talking about today sometimes are impacted by personal injury cases. Dan and I practice in personal injury. Dan, why don't you talk about that with respect to nursing homes for a minute?
Yeah, in every long-term care facility, there are certain standards of care that they have to adhere to. And occasionally what you see with an older person or somebody who's incapacitated physically is they're not getting the care that they're supposed to. Oftentimes what you see is bed sores, they're not being bathed properly, personal hygiene isn't attended to. And these are the things that should be clues to you to pay attention to and see if the care is where it's supposed to be. If it's not, if you see these things, then you need to start talking to that nursing home facility. And if your loved one is in a really poor condition, then you should see a lawyer right away to talk about the other things that you can do. If you believe the person is in danger, then you should try to get that person out of that facility as soon as possible and transfer them to another facility.
What about the fall risk issue? We've got a graphic that talks a little bit about that. Why don't you explain that?
Okay. One of the things that every nurse that's admitting a patient who's in a nursing home has to do is they have to assess the person's fall risk. And there's a special scale that they use to do that. And if a person is a high fall risk, there are things that the nursing home has to do to prevent that person from getting injured if indeed they do fall. There's floor mats, there's bed rails, there's all kinds of other things that they can use, more supervision, people watching that person. So these are all things that you got to be wary of when you have a loved one in a nursing home. You want to make sure these things are being taken care of.
Okay, great. Thanks, Dan. We have Betty on the line from Cincinnati, and she has a question about caring for her father. Betty, thanks for calling.
Hi, thank you.
Go ahead. Tell us what you got, what issues you have or questions you have for Karen.
I take care of my father full time, and I have other siblings, and they don't help me. And he lives with me, but he still has his own house. And the will states everything is to be divided between the siblings. And I was wondering if, when he does pass, I could get paid for all my years of service to him.
That's an excellent question, and something that we hear sometimes. And of course, what we do is we refer it to a lawyer like Karen to get an answer.
Well, one of the things that the probate court will look at is after your father would pass, and you would put a claim in for the services that you have rendered. One of the things that the probate court looks at in Ohio courts in general, they will say that when you're rendering care to a loved one, that's really a gift. And what's very important, because we see this nowadays, a lot more parents or children are caring for their parents, and they may not be able to work full time. They may have to give up their job, and so they're losing some income to take care of mom or dad. And one of the important things to do is to get a caregiver agreement set up. And that's an agreement that allows the child to get paid for their services, a reasonable amount, and they can get paid as they're giving those services rather than waiting until the parent has passed away and filing a claim against the estate.
That sounds like a real practical way to deal with a difficult situation. I think we may have time for one more call. Tim, are you there from Springdale? Well, yes. Okay. John from Morningview.
Thank you.
Welcome to More Law.
Thank you. I'm single, unmarried, divorced, whatever. I'm single. I own property. What were to happen if I became incapacitated, had to go to a nursing home? Is there a way to protect my assets so that a nursing home can't attach my property?
That's a good question. Karen, you want to answer that?
Yes, there is a way that you can plan to protect those assets. Unfortunately, you have to start doing that, and you have to give away your property at least 5 years in advance, because what you're looking at is trying to qualify for Medicaid and having the state basically pay for your care in a nursing home. That's what most people are thinking about when they want to protect their assets. Under the current Medicaid law, the state will look at any transfers of property that you have made within 5 years of the date that you're going into the nursing home. And so if you want to try to protect that property, you've got to give it away, and you can either give it away outright to someone you know, or you could put it in a trust, but you're giving it away, you're making a gift, and that has to be done within 5 years of going into a nursing home. So it takes a lot of pre-planning, and you have to be comfortable giving that property away now.
Before giving your stuff away, you've got to think long and hard about that. We're going to go to break right now, and we'll be back with more calls and more law in just a few moments.